Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have our first webinar of the year in Arizona, a contractors, subcontractors, and suppliers step-by-step guide to getting paid by the amazing Kevin Estevez, a fabulous construction attorney. So without further ado, I introduce Kevin Estevez.
Thank you, Ariella. Good morning, everybody. This is, like Ariella said, our first webinar for the year, and it is going to be a review in some respects of some of the topics we covered last year. But as the title implies, I've taken time to break down what I think are the four main steps that contractors, subcontractors, and suppliers should take to make sure that they get paid in Arizona. And so with that, if you have any questions during the course of the presentation, please drop them in the chat box and we will get to those at the end. So typically in Arizona, like in most states, contractors and suppliers have various remedies available to them in the event of non-payment. Two of the most effective, and what we're going to be talking about today primarily, are mechanics lien rights and payment bond claims. And in Arizona, in most situations, contractors and suppliers must timely serve a proper preliminary 20-day notice to preserve these claims. And that gets to step number one of my top 4 steps for contractors and suppliers to ensure that they get paid, and that is serve a preliminary 20-day notice. As I've said in previous seminars, if you take one thing away from this talk today, please let it be that, and that is to serve a preliminary 20-day notice early, and we'll get to the timing respects in a minute, but serve those notices early from when you begin work or begin furnishing materials to a project. So as it says here in the slides, except for laborers for wages, every lien claimant and some Little Miller Act bond claimants in Arizona must serve a preliminary 20-day notice within 20 days of beginning work. And what happens if you don't serve a 20-day notice? You forfeit all lien rights and you may forfeit bond rights. And if you don't serve a timely 20-day notice, you can forfeit a portion of your lien or bond rights. So we want to get those notices served, and we want to get them served really within 20 days of beginning work on a project. Preliminary 20-day notices are designed to give owners advanced information of the identities of any unpaid claimants who may perfect liens against the property or assert bond claims in the case of the contractor furnishing a payment bond if their debt remains unsatisfied. So the idea behind preliminary 20-day notices are that they put everyone on notice that you as a contractor or a supplier are out on the project and you're performing work or delivering materials and you have a right to payment. So what needs to be in a preliminary 20-day notice, and this will be a refresher of one of the talks we covered last year, but number one, you need to include a description of the labor or materials that be furnished and an estimate of the total price thereof. And the total price estimate is a critical piece of information, and we'll talk more about that in a couple slides. You also need to include the name and address of the person furnishing the labor materials, the name of the person who contracted for the purchase of the labor materials, an adequate description of the job site for identification, and a specific statutory notice to property owner that is set forth in ARS 33992.01C5. So that's the general contents of a preliminary 20-day notice. You can find a sample copy at ARS 33992.01D. and claimants and those furnishing 20-day notices are obligated to substantially comply with the statutory form that you can find there in 33-992-01. So I said the most important thing you can take from today is to serve a preliminary 20-day notice if you're performing construction work in Arizona. Who do you need to serve the 20-day notice on? You need to serve it on the owner or reputed owner, the original contractor or reputed contractor, the construction lender or reputed construction lender, and the person with whom you as the claimant contracted. And as set forth in this excerpt of 33-992-01F, it should be addressed to the recipients at their residence or business addresses and served via either first-class mail with a certificate of mailing or registered or certified mail with postage prepared. And 20-day notices are deemed served when they're deposited in the mail. I talked about the timing requirements of 20-day notices a short time ago, and it's really important if you want to preserve all your lien rights and bond claims on a project that you serve your Arizona 20-day notice within 20 days of first commencing work or furnishing materials on a project. And that's because 20-day notices reach back only 20 days. So if you serve it within the 10th day of performing work or furnishing materials, it'll reach back 20 days. And so and then carry forward from that point going forward. So you've effectively covered your entire time on the project, provided the amount of the 20-day notice is correct. If you wait until say day 30, then what happens in that situation? It reaches 20-day notice reaches back 20 days. So it would take you back to day 10, and you would have lien rights and bond claim rights from day 10 going forward on the project. Again, providing that the amount in the 20-day notice is correct. But in that circumstance, you have a situation where from days 1 to 10, the labor or materials furnished within those 10 days would not be covered. And so that gets into the next couple points here I have in the slide. If you don't serve it within the 20 days after labor and materials are first furnished, you could potentially pick up some lien rights or bond claims if you serve a late 20-day notice, but you're not going to have rights for the entire time on the project. So I've mentioned a couple times now that one of the things you need to make sure of is that the amount of the 20-day notice is correct. So first step is we want to serve the 20-day notice. We want to make sure that it complies with the statute, has all of the requirements of the statute in terms of contents, and that we serve it in accordance with the statute. One of the requirements of the statute is to have an estimate of the total price. And it's important to get this right because in Arizona, a lien is limited to 130% of the estimated amount in the 20-day notice. So if you serve a 20-day notice and the estimate of the total price of the work on the project is $100,000, that notice would confer upon you lien rights or bond claim rights of up to $130,000 if the scope of the work changes and the value of the labor and materials increases. You'd have up to $130,000 in lien rights without having to serve a supplemental 20-day notice. If the contract amount is increased beyond this 130% threshold, the claimant, it's incumbent upon them to serve a supplemental 20-day notice. And again, we want to serve that as early as possible, and you want to serve that within 20 days of first furnishing additional labor or materials. And one key point on this, and I've mentioned this on some past webinars, is that when you supplement a 20-day notice, you don't want to do a piecemeal supplementation. So back to the situation I described a short time ago, you serve a 20-day notice because the contract amount is $100,000. The scope of the contract increases to $150,000. So this is a circumstance where the total value of the work is now above 130% of the amount of the preliminary 20-day notice, and so it would be incumbent upon the contractor or supplier in that situation to supplement the 20-day notice. But the correct way to supplement in that circumstance is to send out a supplemental 20-day notice that has a estimate of the total price now listed at $150,000. And you want to do that and include that total amount rather than a piecemeal supplementation where it says that the estimate of the total price is just $50,000, or the difference between the increased amount and the amount in the original 20-day notice, because there's an argument there that if you just list the increased amount, you're telling those folks who need to be put on a notice by your 20-day notice that the total amount of the labor materials you're furnishing to the project is $50,000, and that could lead to a situation where the supplemental notice is deemed no good, and you have in effect not supplemented notice to preserve your lien rights. So big takeaway is that if you're supplementing your 20-day notice, you want to make sure that you do it and include the new aggregate amount of the labor material and not a piecemeal supplementation. So once you get the 20-day notice served and you start going on the project and work starts being performed, of course you want to bill in accordance with the contract and Arizona's prompt pay statutes to make sure that you get paid, and doing that is one of the easiest ways to make sure that you get paid and you don't have payment issues. But assuming that is done correctly, you want to be cognizant of your deadline to record a mechanics lien or make a payment bond claim. And again, and this is a little bit of a review, mechanics liens apply to private projects, and the lien, by virtue of a lien, the claimant is asserting an ownership interest in the real estate on the grounds that it provided services or materials to improve the property and has not been paid. A few limitations on liens that I addressed more in detail in previous talks. First one is liens cannot be recorded on public property, which we'll get to here in a second with payment bonds. An owner-occupied residence cannot be liened unless the contractor or supplier has a direct contract with the owner. And then finally, if a project is being built for a tenant, contractor or supplier may only have lien rights against tenant improvements. So because public property can't be liened, federal and state law requires payment bonds on projects of a certain size and type. And qualified subcontractors and material men may have claims against the bond if they satisfy those notice requirements. So in short, if you have a private project and you take the steps to serve a preliminary 20-day notice, you're going to preserve your lien rights, provided you take the next steps and the next steps that are required to preserve those. And then if you're doing work or furnishing materials on a public project, probably going to have a claim on the bond if you serve a 20-day notice, and it's a Little Miller Act bond situation in Arizona, and then you take the steps that may be required after service of that 20-day notice to preserve your lien and bond claim rights. Generally, a lien must be recorded within 120 days after project completion. And what is project completion can vary, and it is dependent upon numerous things, and we'll get into those. Completion pursuant to ARS 33993C occurs 30 days after a certificate of occupancy is issued. So if C of O is issued on the project, you have 30 days after that is when quote unquote completion occurs, and then you have 120 days after that to record your lien. If no certificate of occupancy will be issued, completion occurs on the last day when labor or materials are furnished. So in this situation, it confers the claimant the shortest amount of time to record their mechanics liens, absent the recording of a notice of completion, and that time frame is 120 days when labor and materials are last furnished to the project. And again, with respect to mechanics liens, one thing to bear in mind is that when I'm talking about completion in this context, I'm talking about completion of the entire project, not completion of when you as a particular contractor, trade, or supplier last delivered labor or furnished materials to the project. And that's one way that the timing requirements on lien claims and bond claims differ, and we'll talk about that again. Third circumstance here is completion occurs if work is stops for more than 60 days and the stoppage is not due to an active God. So if work stops for 60 days, then you have then that 60th day is deemed when completion occurs, and you have 120 days after that to record your lien in that circumstance. And the shortest time frame you have to worry about as a contractor supplier is the circumstance when a notice of completion is recorded, and the lead recording deadline in that circumstance requires 60 days after the notice is recorded. And in that circumstance, the owner must serve a copy of the notice of completion to every person who served a preliminary 20-day notice. So in that circumstance, you will be and should be served with a copy of the notice of completion. But that is one way that an owner can short circuit its the deadline to record a lien on the project. Those are the circumstances that set forth the time frame for recording a lien on a project, and it's very, very important to be mindful of those. One rule of thumb is if you're not sure what's going on a project and you furnish labor materials and are done, one good rule of thumb is to calendar 120 days from when you last furnished labor materials to record your lien, and that should protect you in most circumstances, except for the recording of potential recording of a notice of completion. But in other circumstances, that should give you enough time to get your lien recorded, and if you record it in that time frame, you will have preserved your lien rights. So what happens after the lien is recorded? You must serve the notice of claim and lien, and here is some information about service. And the basic takeaway is that it should be served within a reasonable time of recording. The phrase reasonable time of recording is not defined in Arizona law, but the good rule of thumb is you want to serve it under the constraints set forth here on this slide, and you want to do that as promptly as possible. Payment bond notice requirements. So part of our third step here on preserving our step-by-step guide to getting paid in Arizona are on step 3, where we're talking about knowing the deadline to record mechanics liens, or conversely assert a bond claim. We are moving now on to the deadlines to assert bond claims, and you could run into two types of bond claims in Arizona, and I know we want to keep this short today, so I'm not going to talk too much about Federal Miller Act claims, but I will talk about Arizona Little Miller Act bond claims here on this slide. And it, as set forth, any claimant who has a direct contractual relationship with the subcontractor of the contractor furnishing the payment bond, but not a contractual relationship express or implied with the contractor, has a right of action on the payment bond on giving the contractor the following notices: a written preliminary 20-day notice that we just talked about here as our first most critical step, and then a written 90-day post-completion notice. So there are two potential notice requirements to preserve bond claims. You have the preliminary 20-day notice, and you have the 90-day post-completion notice. Those that have a direct contractual relationship, though, with the contractor furnishing the bond, are not obligated to give those notices. And so here's a brief chart here that covers who's protected and what notices they have to give. So in the circumstance of a Little Miller Act project, it's going to be your general contractor that is likely to have furnished the payment bond on the project. And then the first tier subcontractors and suppliers are certainly protected. In Arizona, they do not have the notice requirements. And if you think about it, that's the same thing with a mechanics lien. You want to put the owner on notice of those out there being paid. In a bond situation, the idea is to put the general contractor who is furnishing the bond on notice of the potential bond claimants. So those subs and suppliers that have a direct relationship with that general contractor, presumably the general contractor is going to be aware of their existence, and so the 20-day notice and 90-day post-completion notices are not required. The second tier subcontractor and the second tier supplier listed towards the left side of this screen, they are not in contractual privity with the general contractor furnishing the bond, and so they are protected, but they're protected provided they give the notices that I addressed in the previous slide. So that is step 3. That is the timelines we want to worry about to either make a bond claim, or number 2, assert and record our mechanics lien. Step number 4 is we want to know the deadline to file suit to foreclose on the lien or recover against the bond. And so once you get a mechanics lien recorded, you have 6 months to sue to foreclose on that lien. And a foreclosure asks the court to order the sale of the property to satisfy the lien, and claimants with valid mechanics liens share the proceeds. And so if no foreclosure action is filed within 6 months, the lien expires by operation of law. And one important point to take into consideration is that when we were talking about the deadline to record your lien with the county recorder in which the project is located, the county recorder in the county in which the project is located, we were talking about timeframes in 120 days, and those timeframes can be up to 180 days. The deadline to sue to foreclose on the lien is 6 months, and 6 months can be different than 180 days. So that's something that needs to be considered when you are reaching the point now of you served your 20-day notice. You've billed in accordance with the contract and Arizona's prompt pay statutes. You haven't been paid. Then you've recorded your mechanics liens against the property with the right county recorder, and then you're now in the situation where you're suing to foreclose, and you want to be able to calendar that accurately. So pay attention. It's 6 months, not 180 days from the date that the lien is recorded. With respect to payment bond claims, if you have a Miller Act or a Little Miller Act claimant situation and you're claimant on a bond in that context, you may not bring a lawsuit to recover on the bond until 90 days after the last of the labor was furnished or materials were supplied. And so that allows the circumstance where you have to give a 90-day post-completion notice if you're one of those subs that or suppliers that has to give that notice, allows that to happen, and then after that time frame is up, you can go ahead and sue to collect on the payment bond, but you only have a year after the date that you last furnished materials or supply labor to a project. So this is different, as I mentioned earlier, from the circumstance on calendar deadlines on mechanics liens, because in that circumstance you have 120 days from a completion of the entire project. In a payment bond circumstance, you have a year after you last furnished materials or labor to a project. So that's the 4 steps that I wanted to cover today to sort of set up the things that you need to do to preserve your lien and bond claim rights to ultimately get paid on a construction project in Arizona. Again, what I talked about today was highly nuanced, and there's a lot of detailed technical requirements and exceptions to both lien claim and bond claims in Arizona. And this presentation can't substitute for specific advice. If you do have specific questions, I would encourage you to please consult with a qualified attorney. If there are any general questions, I would, though, however, be happy to answer those now. And so with that, I will turn it back over to Ariella, and then we will wait for any potential questions.
Great, thank you so much, Kevin. There aren't any questions at the moment, but we have some suppliers on this call. And one of the interesting things about Arizona versus other states that some of the suppliers are on the that have experience with construction liens is that if you're working for a subcontractor or general contractor in other states, you can send your preliminary notice on residential projects, and you do in fact have lien rights. Arizona is a special state where if you are not contracted directly with the owner of the property, you can't lien the project if it's residential. So what do you tell your clients to do in those circumstances so that they, should they do direct purchase orders? Should they do just what do you think about that?
Yeah, that's a good point, and it can provide a tricky situation, certainly for subs and suppliers on residential projects. The direct purchase order for materials, like you mentioned, is a good solution. Requiring more money up front or payment in a short amount of time is another potential solution to protect your right to payment. And then be familiar with the general contractor on the project, their credit worthiness. Those are all things to consider when you are either furnishing labor as a sub or materials as a supplier on a residential project, because in most circumstances you won't have lien rights. But for sure, I mean, if you can get in a situation where you deal directly with the owner on a project, then you've crossed that bridge and you have that direct contractual relationship with the owner occupant, and you would have lien rights in that circumstance.
Wonderful. And I'm sure if anyone has any questions or they would like to create a joint check agreement, they can always reach out to you, and you and your firm can prepare those for SunRay's customers. And you know what? You did such a great job. There aren't any questions at the moment, but if anyone does have any questions, please feel free to reach out to us at any time. And Kevin, you did a wonderful job as always.
Thank you so much, Ariel. Have a great day, and everyone, thanks for attending.
Thank you. Have a sunny day.